This is the first time we've had our lunch session in this room that I can recall, and it's worked out pretty well. I like it. We couldn't have a more important subject, and we couldn't have a more distinguished, relevant visitor to guide us on that subject. This seems to be my week for catching up with former students. Yesterday in the criminal justice seminar, the speaker, Professor Penrod, I was trying to meet him. I didn't know I knew him because my grandson may want to work for him this summer. He's interested in psychology and criminal justice. And I said hello to Penrod, and I looked at him, and he looked at me. He said, "I took your course in 1976. And then today, when Mr. Jardeleza came in, I knew him immediately. I had seen in his bio that he was in the class of 77, weren't you?
Yes.
Yeah. And I was running the graduate program then, so I knew we'd seen each other, but I didn't realize until he confirmed it this morning that he took my course on China. Now that's what you call a student having foresight. Because 37 years later, he's playing a key role in what I think is a too little noticed but truly momentous event, process, decision that involves China and international law. As you know, until 71, when China came into the UN, it was not a supporter of the current international system. Since 71, for 40 years, China has played an increasingly important participatory role, including, as some of you know from our course the other day, participating fully in the World Trade Organization, despite the obstacles that it had to confront, including the arbitration dispute resolution procedures of the World Trade Organization. Now, the significance of this matter is China signed on to the Law of the Sea Convention, which also has compulsory dispute resolution procedures. And the Philippines is putting them to the test. Is China willing to use these procedures? And so far, as you know, the results have not been good, but this has, I think, terrific meaning, and I hope the Chinese government will be reconsidering its position. I don't think it's too late, but we couldn't be luckier than to have Mr. Jardeleza come here at this time. Yesterday, he was back at the old soil at Harvard giving a talk, and his two remaining talks on this subject during his current visit are here in New York, today with us and this evening at the Council on Foreign Relations. So I want to just ask a few personal questions. They have your biography, which goes into your distinguished law firm practice and all that. But what is the Solicitor General of the Philippines? Is it analogous to the organization of our Justice Department, where you have an Attorney General and then a Solicitor General, or is it in some way a variant? How does that work?
Yes, it's essentially the same. We have a Secretary of Justice, which would be the counterpart of your DOJ, or Department of Justice.
And
there's a separate...
You're responsible for all litigation?
Yes, all litigation. We are the law firm. We represent the Republic.
How big is your office?
Oh, we have around 250 lawyers.
Wow. 250 lawyers?
Yes.
That's quite a law firm to run.
It's the biggest law firm of the country.
Oh, it's even bigger than CSIP Salazar?
Oh, bigger. CSIP Salazar would probably be 100.
Oh.
And that's why I always joke, you know, I never became senior partner of a big firm. I was with a firm and transferred to a company. So I'm having my revenge. You know what's most interesting about having the biggest law firm of the country? for those of you who practice law, I don't have problems raising revenues.
Well, I also noted that in your career, you were general counsel of San Miguel Corporation.
That's right. That's the beer company in the Philippines.
Well, San Miguel was my favorite beer for years when I lived in Hong Kong.
Yes, yes.
And I don't know how readily it's available here. Nobody ever suggests it when I go to a restaurant.
It's a matter of logistics. Very, very quickly, Europe is 5 hours away, and we are 22 hours away. So you would know the cost disadvantage.
Yeah.
It's
Well,
as simple as that.
how
But we're
did
still
you-
the number one beer in Hong Kong.
How long have you served as Solicitor General, Francis?
Oh, I've just finished my full year. I retired from San Miguel around 2 years ago. As I told Ira, I'm like kind of like giving back phase in my life, and I'm very blessed to be thrust upon very important things for the Philippines. It's the most important thing I'm doing right now.
And is this your first sortie in the international law field, or have you been involved in other international law matters?
Yeah, yes, this is my first time. I mean, I've been doing mergers and acquisitions and corporate things in the last 15 years. But
It must have been a very difficult decision for your government to decide to take this matter to law, to the Law of the Sea Tribunal. Ironically, I should reintroduce Professor Peter Dutton, who has spoken here before and has taken part in our classes. But Peter and I have had a small group trying to get acquainted with the legal officials of the various players in the East China Sea. We've met with the Japanese, and we have a representative of the Japanese Consulate General here. We've met with the Vietnamese, we've met with the Chinese to hear their positions on these law of the sea and territorial matters. And we couldn't figure out, why can't we get in touch with the Philippines? We wanted to meet with them, and all we got was silence. And then we discovered why on January 22nd, I think it was, when you filed your suit. But you obviously were preparing for a long time, and you filed a beautiful document. When I read that document, I said, boy, these guys are good lawyers. I think it's very artful, and I hope you'll give us some of the background, including, I gather you've prepared some PowerPoints on this. So as the Chinese say, please educate us, Qing Zhao.
Thank you, Professor Cohen, and thank you, everybody, and good afternoon. Well, I know Professor Cohen. He was former prosecutor, so he warned me. But I know that he, in things like this, he would like to start peppering the guests with questions, and so I made a deal with him. It's like some kind of a plea bargain. I said,
You can always take the Fifth Amendment.
I will just walk you through very few slides, and then I'll be prepared to take the questions. And then, at the end, just tell you why we went into this, and we can get into details on how long the preparation was, how difficult or how easy it was. So thank you again for giving us this opportunity. Well, just the first slide will just show you for again, to remind us where the South China Sea is. There are really three groups of insular features there. The paracels do not concern the Philippines, it does other claimants. And today we will be focusing on two groups, the Spratlys and Scarborough Shoal.
What is Scarborough Shoal? We know something about the paracels. We know a little more maybe about the Spratlys, despite there's so many of them. But how would you characterize the Scarborough Shoal?
The Scarborough Shoal is a submerged reef. It's a group of around not more than 6 protrusions. They are at high tide, the protrusions are not more than 3 meters
Is that
tall.
it?
Yes, yes. A group of 6, so protrusions not more than 3 meters high.
And we're looking at all of them together?
You're looking at all of them.
Doesn't seem to be room to change your mind.
And Scarborough Shoal is 120 nautical miles from Luzon. That's Philippine Islands. So that's typical of what our claim is all about. The suit, the arbitration covers only 8 features, 8 maritime features. 4 of them are completely submerged. Completely submerged.
Low tide,
Low tide elevations, completely submerged. Nothing is above water at high tide. These are, if the names will be Mischief Reef, there's McKinnon Reef, Gavin Reef, and Subi Reef.
and there's a dispute with China over ownership, sovereignty over these features.
Yes, these 4 features which are completely submerged, China claims sovereignty and sovereign rights, and that's an example. Subi Reef. It's a picture taken from the top. It's completely submerged, but you can see the contours. And two of these submerged reefs are clearly within the Philippine EEZ.
They're within the Philippine exclusive economic
Exclusive
zone.
economic zone.
Only
So-
2 of them?
Only 2. One is 205 nautical miles, which is just barely out of our 200 economic zone, and another is 230 miles from the nearest island. So they're very near.
So there's dispute over sovereignty over all these features.
Yes, yes. So that's the 4 completely submerged reefs.
But your lawsuit doesn't concern territorial sovereignty, does it?
No, absolutely not. And that's why we thought we crafted a very precise submission. We are not, the Philippines is not asserting sovereignty. This is all about interpretation and application of the UNCLOS, basically, essentially, the regime of islands.
What's at stake here? Why did you bring this suit? What have you been discussing unsuccessfully with the Chinese?
Well, we have for more than 17 years, we have had bilateral talks with China dating back to 1995. And, all the Philippines is saying is apply UNCLOS. You start with our 12 nautical miles territorial sea. We start with our contiguous zone, and you start with our 200 economic zone and our continental shelf. And if applied and measured correctly, then areas beyond that, we apply again the UNCLOS provision on regime of islands. Let us sit down and see which ones are islands, which ones are rocks, and which ones are neither. And our position is, I go back, there are 8 features in dispute. 4 are completely submerged. So under UNCLOS, they do not generate any maritime entitlements.
They don't get a territorial sea.
No, 0. No. Of the four which have 2-3 meters above high tide, then we discuss, are they islands or are they rocks? Our submission is all of them are at most rocks, which will generate at most 12 nautical miles territorial
So there are
sea.
4 features that are visible at high tide. They're above.
Yeah, yes.
You can see them.
You can see them. And
That's what we were looking at before.
And we'll show you the next slide. This is Mischief Reef. completely submerged at high tide, but where the Chinese have, from you can see from the picture, have made constructions.
Mischief Reef is well named.
Yes, and and this was where the Philippines was literally excluded. But
That's visible at low tide. Mischief Reef.
well, now they have made it into an artificial island, but Mischief Reef itself is submerged.
So the Chinese have built upon
They
it,
have built upon it.
an artificial construction that's visible at high tide also.
Oh yes, of course. Now visible at the high tide, but our position is this is an artificial island which is not entitled to any maritime entitlement under UNCLOS.
Yeah. So you disagree who owns the reef, but beyond that is the more important question of does it generate anything entitlement under the law of the sea treaty?
That's right. Whilst we disagree on who owns the sovereignty, we are not presenting this as an issue for the tribunal because we know they have no jurisdiction on that.
On the who owns it?
On the
question.
who owns it. And,
Yeah.
and we can set that issue aside and we just want a ruling and a binding arbitral ruling on, not without deciding who owns it, how much entitlement does it generate.
This is a key question in the East China Sea also. In the recently even more publicized dispute, look at the New York Times today, over the Senkaku Diaoyutai. Many people think the issue could be resolved more easily or reduced in significance if the parties could agree that these are just piles of rock. They're not entitled to more than a territorial sea. They're not entitled to exclusive economic zone, etc. But they haven't been able to agree. So part of your difference with China is over how do you characterize these features and to what extent they should enjoy some kind of maritime entitlement.
Yes, absolutely. It's only a question of what are these? Are these islands? Or if they're not islands, are these rocks or they are not rocks? And it's only the entitlement, not sovereignty, not ownership.
And as the Solicitor General's reference suggests, Rock Island, this categorization is critical under Article 121.3 of the Law of the Sea Treaty in order to ascertain, does this feature get only 12 miles or is it entitled to 200 nautical miles economic zone and any adjacent continental shelf? I want Professor Dutton to correct me. I'm trying to move this along, but I don't want to misstate or oversimplify. And if we have any other experts who want to, as we say in Chinese, 补充一点, don't hesitate. We have a professor of international law here from Jilin University who's at Columbia this year.
I just want to make a quick comment. Because we're recording, before you speak, please use the microphone. Yeah, so when we put it up on the website, we can hear everybody. Thanks.
Mr. Solicitor General, do you have any objection to our recording this or putting it on our
absolutely-
website?
Absolutely none.
Yeah. I should tell you, our regular website, as far as we know, is blocked in China. So you won't reach a broader audience that I would like to. But maybe we'll think of some way. So, but look, you've already told us that this arbitration, in part, is over these questions of how you characterize the features and what they're entitled to. But what really interests some of us, I think what you've done in this respect is very good, as I've indicated, could be helpful in the East China Sea if they did the same. But what really interests us is this famous 9-dash line. Don't you also challenge the 9-dash line in your arbitration claim?
Yes, we are. And the way we are challenging the 9-dash line, again, is we go back to UNCLOS. Because China in 2009, in a note verbal to the United Nations, laid for the first time, formally disclaim about the 9-dash line. And we are at a loss on what the legal basis would be beyond the map attached. And so we go back, and the submission goes back to UNCLOS. You always measure from land. Land dominates the sea. Many parts of the South China Sea is 800, 900 miles from the nearest Chinese mainland. And therefore, the way we're going about this is we're showing that if you start from the main lines, the broad main lines, the Philippines, there is, in our view, absolutely no legal basis under UNCLOS for that claim for the so-called 9-dash line. And the way we have asked the tribunal to declare it as invalid is that from all of the UNCLOS regime of islands and land dominates the sea, I go back, there is absolutely no legal basis for this 9-dash line. And
Do you have something? Oh, good,
yes,
there it is.
it's on the screen. If you count, there are 9 broken lines. The nearest Chinese mainland will be Hainan. You see the Philippines, the 9-dash line cuts, that's around 50 nautical miles. It cuts through or cuts off the Philippine 200 economic miles. It also affects Malaysia.
Yeah, very close. And look
And
at
you see
Indonesia.
again Vietnam. I think they're all the line in Vietnam is almost also 50 miles away from the Vietnamese landmass.
Well, you can see in the Gulf of Tonkin, it used to be an 11-dash line. But China and Vietnam reached an agreement. And it became a 9-dash line because the
Yes.
other 2 parts are now irrelevant. Tell me, you have a rather narrow depiction of the South China Sea there. What is that? Does that indicate waters beyond everybody's 200-mile economic zone? How do you define the South China Sea for that purpose?
Well, that you are right. If you extend the 200 miles of the littoral states, that's about what would be left. What would be left of the South China Sea? What would be in terms of the definitions of UNCLOS? That would be like the truly high seas part of the South China Sea.
This begins to focus our attention on part of the U.S. concern here. China says this issue is none of our business. We say freedom of the seas, freedom of navigation. And if we take account of that, does it mean there's no total freedom of navigation for U.S., Japan, other countries outside the area, except in that narrow area you've called the South China Sea?
Well, absolutely not, because then UNCLOS still regulates. There's still freedom of navigation. So
You can go through
yes, you can go
economic
through
zones.
economic zones.
Warships?
That's not an issue. I mean, there are rules under UNCLOS, and
One
That's
thing
a-
we see from this is that the line, the 9-dash line, as you point out, is very close to the Philippines. It goes through your economic zone.
yes, cuts it off.
And is your position that the 9-dash line is a violation of the law of the sea treaty?
Yes, absolutely.
And so you brought this arbitration for more than one purpose. One purpose you started out by showing us is, what do you do with all these features? And what claims do they justify? And then you have the 9-dash line, which seems to go far beyond anything claims based on individual features could justify.
That's correct. That's the equally that's the equally other big purpose or big reason for bringing this suit or this claim.
Ira Belkin,
Sorry to interrupt.
you want to use the mic? Yeah.
Sorry to interrupt. Maybe I'm the only one who is ignorant of this, but
You're not.
what's the significance of the 9-dash line? What is the 9-dash? I get what the features are. Where does the 9-dash line come from?
Yeah, good. That was the next point we were going to get to.
Sorry.
The 9-dash line apparently first came into view before the People's Republic was established. The Chiang Kai-shek government in 1947 put out this 11-dash line. And the PRC inherited this position when it became the government of China. And the 9-dash line is something of a mystery to people because although Chinese scholars have offered different explanations for it, including its application and significance, the government of China has been slow to articulate what is the basis for the claim and what are its consequences. Peter, would you like to embroider that a little bit?
Certainly, the Chinese have remained ambiguous about what the 9-dash line means. There are multiple approaches taken by multiple parties. Some academics, some ministries take different versions. But at the heart of it is that it's about long historic rights. China views itself as having historic rights in these waters. Depending on who you talk to, there are different versions even of what those historic rights are. But in the end, China is claiming that there is some sort of historic rights that attaches to the area within that 9-dash line. And I think the heart of the dispute is that it's either historic rights can prevail or the geography-based approach of UNCLOS that can prevail. And I think, if I understand correctly, that is the basis of the challenge to the 9-dash line. Am I right?
Yes.
Yeah, thank you.
Going back to the first thing we talked about the 8 features at issue.
Use the mic so I can hear you.
Sorry. Going back to the first thing you talked about, the 8 features that you're arguing about the status of, what is China's position on the status of those 8 features?
They are all occupied by China. And
But about-
the difficulty we have about position is beyond they're occupied. The difficulty, and I'll swing to the next issue, is as you know, China has chosen not to participate. So, commenting on what Peter said, we may or we may not have the opportunity to officially hear from China as a state party on what exactly is the basis of the claim. They have not said anything. They are there.
They are simply Chinese.
Yes, yes. And it is on this matter about, just like in Cambridge yesterday, we were asked, so what do we think is the Chinese position? And you will not hear anything from the Philippines. We respect, they have, they have to say what they have to say. But since we are in arbitration, the Philippines will not speculate on what the claim is. It's going
But
to be
you've talked to them for 17 years about these questions. They must have said some basis. I mean, if I say, this bottle is mine, somebody will say, well, how do you know? And you must have asked them about the shoals, about the reef. Is that all based on the 9-dash line, or are they saying everything within that line, that's a real South China Sea, that's not that narrow band, everything within those dashes belongs to China? Is that?
It's as Peter says, it's a little bit of all of those things. So it's difficult to pinpoint it, and there's officially no record, and and that's why we hope the arbitration will get us to somewhere.
Did the Philippines occupy any of these disputed features?
We are in 6 features in the Spratlys. We are in 6
You're
feet.
still there?
We're still there.
Has China dislodged you from any of the disputed features?
Mischief Reef. We were dislodged by China from
Mischief
Mischief
Reef.
Reef.
Yeah. And they have not responded to any protests about what they've done there?
Well, we have protested. We keep protesting. In last year, 2012, that's when they made a move on Scarborough Shoal. And maybe we have the next slide. They have, as of now, since they made the move in Scarborough Shoal, they have 3 vessels inside the shoal, and they have prevented Philippine fishing vessels from fishing near the shoal, and then they continue to fish, take advantage of the living resources. And in our view and in our submission, they have been harvesting some endangered species in Scarborough Shoal.
Can I ask a question? Can I ask a question?
Yeah, sure.
Sorry. When China proposed the 9-dash line in 1947, was it agreed upon by the neighboring countries at that time?
There is a dispute on what was agreed or not agreed. But for example, in the case of the Philippines, since 1995, and I say for 17 years, we have always been asserting that we have not recognized the non-dash line. And I think in 1947 it was first published by the Taiwan government.
Well, they were then still
were-
in Beijing,
they were
or
still-
Nanjing. Nanjing was the
yes,
capital.
Yes. So
Yeah.
that's going to be one of the issues in the arbitration. China claims sometimes that they have been there since time immemorial. Sometimes the claim would be that, since for 50 years or 60 years. So again, as Peter says, it is difficult to pinpoint. And again, we're hoping that, an international arbitration under UNCLOS, where you have eminent experts on the panel, will sort these things out. Unfortunately, as we speak, China has chosen not to participate. And
The question is sometimes presented as one of the law of the sea treaty versus the 9-dash line. But as Professor Dutton notes, there is a provision, isn't there, in UNCLOS about historic rights? Could you explain that? Because that may be a crux of one of these problems.
There is a provision in called historic bays, actually. But this is limited to internal waters, that is to say, inside the baselines.
Like the Gulf of Bohai near Beijing
Yes.
and Tianjin.
That's exactly right. And so
How do
this
you
is
know
a,
it's limited?
a very limited exception in UNCLOS, right? There's no other place in UNCLOS that talks about any kind of historic rights. Everything else to seaward of the baselines is based on geography and the baselines. You get zones based on legitimate baselines. So,
What is the phrase used? Historic bays?
yes, historic bay. I don't remember off the top of my head which article, but it's one of the
So
early
is
articles.
is the Chinese position potentially that the South China Sea, it's named after China, that the South China Sea is, if you understand history, simply another example of a bay?
Well, as the Solicitor General points out, we don't actually know because the Chinese haven't told us. But in talking to the leading scholars and officials in China, no, that would not be what the Chinese are claiming. It's more like the Chinese are claiming historic rights, similar to what I would say are EEZ rights, but just they're claiming it based on history to an expanded area that is not directly connected to geography.
But what is the background of the negotiation of UNCLOS with respect to this question? Did they address this problem? Can you have historic rights that don't come within the wording of UNCLOS? Is this just something that's added on to the law of the sea? How comprehensive, how exclusive is UNCLOS?
This is actually a question I think the arbitral panel will help us to answer because it has never been addressed before. It's a very good question, which is to say, to what degree did UNCLOS cut off any previous customary international law that might have been developing. We don't know. And there are some ancient threads, ancient, I mean, 100 years or more since they have been applied, threads of international law that allowed historic rights to small places like sponge beds or something like this on the seabed. But
These weren't raised as questions at the time the Law of the Sea Treaty was negotiated?
they were surpassed actually beginning with the 1958 negotiations in the continental shelf negotiations that led to the 1958, the first series of United Nations conventions. So for most of us international law specialists, we see them as having been cut off by treaty law beginning in 1958. But others might claim otherwise, and we'll see
What's your position?
what they think.
Mr. Solicitor
Our
General?
position is simply that when UNCLOS was drawn up, the treaty, UNCLOS as a treaty, cuts off everything. Otherwise, sometimes the claim is based on historic rights, which is slightly different. Sometimes they say it's historical title, and it seems to be historical title is broader than historic rights. But we argue advisedly, UNCLOS talks only of historic bays, and these are particular bays were related to fishing rights. So that's one of the things that is going to be, we hopefully, the arbitral panel will clarify for us.
Well, of
Because
course, we shouldn't assume if historic rights or title or bay is relevant here, that China's the only country with a history.
Yes, otherwise, then other countries will make similar claims, and then what happens to UNCLOS?
I often say geography is destiny, and all the countries on the South China Sea undoubtedly will be able to produce documentation of one kind or another to show they too have had historic rights. So this could be quite a slugging match for historians here if the Law of the Sea Arbitration Tribunal should think China's entitled to present this argument. It won't get there if they say UNCLOS cuts off this kind of claim.
That's right, and again, it's a pity if China continues not to participate. The advocacy that will be before the tribunal will not be as adverse as it could be to help answer all of these questions.
You see, my interest in the case is several, but one is trying to get China to participate in the process to which they committed China. But another is, I think the South China Sea can be negotiated feature by feature, even though there are over 130. Once this incubus, this vague claim of the 9-line is lifted, if that can be dissipated, then the countries can have intelligent discussions about all these things. First, starting with defining each one, you could do an inventory. As you say, this one is nothing. This one is a rock. This one is an island. And then you begin to see, well, if we can get agreement on that, maybe via a joint commission or something. But none of that's possible as long as you have this thing hanging over you of very vague implications and characterization. So I'm excited about the possibility that your arbitration claim might solve something. But can you tell us a little bit about the legal structure here? How do you bring a claim? You can't do this very readily to the International Court of Justice unless compulsory jurisdiction, the optional protocol, has been accepted. Japan has accepted it. U.S. hasn't. How about the Philippines?
Well, we and China have accepted it, and
You and China?
yes.
Wait a minute. China hasn't accepted the optional protocol to the ICJ. I'm talking about the ICJ.
Oh, the ICJ.
I'm not talking about the.
sorry. Okay.
China has accepted, as you say, the Law of the Sea Tribunal. But could you tell us that offers some options, doesn't it?
Yes, it does. But then going to the ICJ, again, we'll have the consent of both parties. And we thought about it a lot, and that's why we
Did you consider going to the ICJ?
Yes, but we were not confident that China will agree, from all that China had been.
You're a master of understatement. Yeah. So you knew they would have to go to the law of the sea
Yes,
system.
yes. And we know that they had taken advantage of the opt-out clause, in sea boundary delimitations, or if it involves military or naval action, these are exceptions. And that's why, again, we go back, we drew up a very narrow, limited claim only on application of interpretation of UNCLOS. And
When you ratified UNCLOS in the Philippines, you did not make a selection, did you, of what mode of dispute resolution that they offer you would select?
No, we did not, and that's why we fall into the default arbitration mode, which is what they call Annex 7.
Yes. And China didn't make a selection either.
They did not make a selection either. That's why we went under an Annex 7 arbitration. And
In other words, there were 3 other options.
yes.
There are 4 in total. And if you don't choose one of the 3 in advance, you're left with the default option, which is the arbitration procedure you have invoked.
Yes. That's Annex 7, where we file a claim, we name an arbitrator, China names an arbitrator, and 2 arbitrators name 3. But since China chose in a note verbal to the Philippines not to participate, so far, UNCLOS president has appointed the arbitrator, who should have been appointed by China, and the UNCLOS president, because of the continued non-participation of China, is in the process of naming the next 3 arbitrators.
When you filed your submission, you also named your arbitrator.
Yes, we named Judge Wolfron, formerly UNCLOS.
You could have named a Philippine or not.
We could have named a Philippine, but the stakes are so high that we would rather name somebody who is, to start with, non-Filipino and eminent in this field, and would be in a good position to be able to engage the other arbitrators in a good conversation and arrive at a decision which would reflect what UNCLOS is all about.
Next Monday, my class will deal with international arbitration of commercial disputes with China. And one of the points I want to make, I hope I remember, is when you select an arbitrator, you not only have to select somebody who's likely to vote for you, but you have to select someone who can also persuade other arbitrators.
Absolutely.
If you just pick one fellow who's going to vote for you, you may lose.
Right. We're talking here of 5 arbitrators, and if we name a Filipino, you still have to worry about the 4.
So you picked a well-known person.
Yes.
He has served on many arbitration tribunals.
Many arbitration tribunals. He has a great resume. He's well respected, and we're very confident that he can stand his own against the other eminent experts that we expect the UNCLOS will provide for us.
So the next step was for China to respond and put in its arguments, arguing, for example, there's no jurisdiction
Yes.
in the arbitration tribunal because of certain exceptions, and naming an arbitrator to serve on the tribunal.
Well, they did not.
They did not.
And-
They have not named an
They
arbitrator.
have not named, and so UNCLOS has named Judge Polak of Poland as the second arbitrator.
So the administration of the law of the sea process tribunal, they have named a Polish expert.
Yes.
Right. Then 3 more arbitrators had to be appointed.
Yes.
And in the default situation, it's for the law of the sea administration to to appoint those three.
That's right, and we're hoping that they'll name the next three to be as eminent experts and authorities on the law of the sea.
Why aren't they already named?
Well, it's still in the process.
I know, but why does it take so long? I thought it would be done by now. Is there some extension?
No, there's no extension. They are within the 60 days. In fact, it's
you have
kind of
60
accelerated. Yes.
So when will that time expire?
I believe in the next 2 weeks we'll probably get the full constitution of the tribunal.
And do you make suggestions from a list, or do you have no part in this?
There is room for consultations, but the fixed list, if you might, is something that the member states, the state parties, have submitted to the UN. So there's a list of arbitrators from which
you were only permitted to pick from a list that's pre-accepted of experts from various countries?
Well, there is room to suggest. There is room to suggest, and it's really up to the party to whether to suggest or not.
So this will be a very delicate choice for, is it the president of the UNCLOS Law of the Sea Tribunal who makes these selections?
Yes, it's the president of UNCLOS.
And the president happens to be a Japanese expert, does he not?
Yes, that's Mr. Yanai of Japan.
So you can see Japan having a stake in this whole process, as well as the questions involved, has to be very delicate here.
It is very
whom
delicate.
They're going to appoint because of the implications for the East China Sea questions as well as South China Sea. Professor Julian Koo.
Hi.
Yes.
I just had a very short question. On the list, if you select an arbitrator, they can decide not to accept your suggestion. They don't have to serve. They're not obligated to serve. So, for instance, if the president, Yanai, chose a Chinese national to serve on the arbitration panel, that person could decide not to serve, or do they sort of have to serve?
I think the person can decide not to serve.
Well, what is going to happen if China persists in its current posture of saying, we're not going to pay any attention to our commitment to take part in this process? It's too important. Let's go back and negotiate. I noticed they had a representative of their Ministry of Foreign Affairs in Manila recently. And according to the media, he threatened for the next 4 years, the time he anticipates this process will take, that Manila, the Philippines, is going to have a lot of unfortunate situations with China economically, a real economic sanctions threat. Let's assume China continues with this posture. The process will go on, won't it?
Yes, the process will go on. The tribunal will take or direct us to come up with arguments. They may direct us to cover the question of jurisdiction.
And who will appear to take the Chinese position?
I understand from our lawyers this is kind of the first, this is a case of first impression in that sense. So we do not know who will take the cudgels for those arguments. But to answer your question, in due time, after all the memorials are in, we are hopeful that we will get an award which will be favorable. Chiefly, number one, that will declare invalid under UNCLOS or under treaty law the Chinese claim on the 9-dash line. And hopefully also a clarification on the status of the contested features. Hopefully at the most, the tribunal will say that even if there's a rock, it's entitled only to 12 nautical miles territorial sea. And provided there's a declaration that the EEZ of the Philippines is within 200 miles and the Philippines is guaranteed unimpeded use of living resources and exploration of non-living resources within our 200. The Philippines, as a law-abiding citizen of the law of nations, can take it from there. And this is where Professor said, the Philippines, and we'd like to clarify, is open to cooperation. provided there is some declaration about the validity or the invalidity of the 9-dash line, because until that is clarified, you see where we are. The line cuts off within 50 miles of our EEZ. And so if there is a clarification, and we hope it is to uphold 200 miles, whatever else is contested, and our president, the President Aquino, has already said, we are open to cooperation. We are open to negotiating a multilateral code of conduct for whatever is considered disputed areas within the South China Sea.
If the tribunal grants the relief you request, that would make negotiation much easier if the PRC accepts the outcome, because then you have much more clarity. Claims have been reduced, maybe to resolvable fashion. It will facilitate even discussion over sovereignty over these features. It would be good, but the big question is, what will China's attitude be? Will they say it's illegitimate, it's not persuasive, they won't accept it as the basis for negotiation? What are the options, Peter?
Well, the Chinese response, again, we don't want to speak for the Chinese, but the Chinese, at this point, my hope is that the Chinese will use this as an opportunity to engage again in bilateral negotiations, right? So even if, I hope that the Chinese don't wait to the point where there's a decision favorable to the Philippines, as I think the law may find itself in the situation of supporting the Philippines claim, and so that the Chinese might actually engage in bilateral negotiations. Do you see this as being an opportunity to engage again with the Chinese?
Yes, absolutely. It's an opportunity. We are heartened. Many commentators have said that that's a possibility. We are open. There is an ASEAN conference going on in Brunei, and officially our government saying we're open.
They want you to come back to the negotiating table after you give up this suit.
Well,
but you could pursue the suit, and at the same time, it often happens in every litigation, you're an expert on this, litigation often provokes more productive negotiations.
Hopefully.
Yeah, no, I say it's possible.
Possible, very much possible. And our answer is yes, let the arbitration continue, but we're open to talking to directly with China, through other countries.
I had an analogous experience in an international commercial arbitration in Stockholm, where I was one of the arbitrators. And there were jurisdictional questions, then there were questions on the merits of the contract dispute. What China did in that case, and they were the respondent, and they had very good American legal advice from one of my former students, they came in and they argued the jurisdictional points. And they made a good argument, but they lost. Then we scheduled the hearing on the merits, and China announced they're not coming. Now, I thought at least China would do that on your situation. I would have done that because they have a substantial possibility of winning on the jurisdictional question, whether it falls within certain exceptions, etc. And then I thought, if they lose on that, that's plenty of time then to decide whether they want to go forward or not. But to thumb their nose at the whole process ab initio, it seems to me it's a very disturbing situation, and I hope the other countries involved, including Japan and others, would try to put pressure on China to reconsider that decision, because they're committed to this. You can't just ignore a solemn international commitment made in the exercise of your own sovereignty by saying, no, it's not. They could have withdrawn from the treaty. They could have done other legal steps maybe. So, Peter?
Yeah, I have a question for the Solicitor General, sir. You've really helped us clarify the legal questions that you're hoping to resolve. But maybe you could talk a little bit about the practical problems that you hope resolves. If I understand correctly, the point of the litigation is to prevent the Chinese from interfering with Philippine fishing activities and resource activities, that sort of thing, as a practical matter. Am I right about that? And if so, maybe you could talk about that.
Yeah, yes, as a practical matter, you have fishing, and of course the exploration for other resources in the seabed and within the continental shelf. But those things, those practical matters are very important to a small country like the Philippines. And just like when we were prevented from fishing in Scarborough, not only was the act of preventing our fishermen from going there, but again, you have the matter of what's going to be next. The Philippines, as a small country, we don't have much diplomatic or no military leverage. The question of what next. When our fishermen were prevented from being in Scarborough Shoal, we had our expert advice. We can have temporary measures and things like that. It always goes back to when you don't have much economic, political, or military leverage, and that's what's it is great about the rule of law, and we are all lawyers. You come back, there's a treaty, the people, the members of the international community live by rules, and there's a lot of political pressure also from the Filipinos. So where can we turn to? And that's why you have treaties and international bodies and arbitration, because all of these things can be taken up. So yes, Professor Peter, these practical things led to where we are now. I mean,
I should
the
point
Philippines
out-
has no more options.
I should point out this argument is a very persuasive one, and your brief makes it very eloquently. That is the international community going to be governed by force, or is it going to be governed by accepted rules? And force is a very unfortunate thing to be exercised, and it puts the weaker parties at a definite disadvantage. And China, when they first got introduced to Western international law, accepted it eagerly as a defensive weapon against the aggressive imperialists. And the missionaries who helped them in the mid-19th century made this case. And even before the first American treatise on international law by a man named Henry Wheaton was translated and published, China used it in order to get rid of a Prussian ship that had gone into their internal waters in the Gulf of Bohai. And when international law was taught, it was first taught in these armories that China created as institutions to teach how to defend the nation, mostly focusing on warfare instruments, but including international law. So here, a century and a half later, to see international law being invoked against China to defend against now a rising or risen China, it's rather moving. And I hope it's a lesson that Chinese leaders will appreciate what you're doing. Julian?
Yeah, I just wanted to ask just a couple details I'm just curious about. In a domestic litigation, as I'm sure you know, sometimes you give the other party a last chance before you file the lawsuit to say, okay, we're prepared to file a lawsuit, we're ready to go, but here's, are you ready, can we, or is there some reason you think we should continue talking? I was curious whether the Philippines gave China a last chance or some warning that they were about to bring this lawsuit, or whether you just said, oh, we're filing a lawsuit, and then China, sort of because they didn't have any notice, is that part of the, maybe one of the reasons why they reacted so negatively? And then the other questions is on the back end, as a legal strategy. Suppose you do win a judgment from the arbitration tribunal, and China just continues to ignore it. Is there a reason to think this will make a difference in their behavior, given that the other countries in the region haven't been particularly enthusiastic, or have they, about saying this arbitration is really important? Have the other ASEAN countries or ASEAN itself, have they made any statements in support of the idea of the rule of law or the idea of arbitration in a matter like this? So those are two questions.
Very good questions.
On the first one, I will say, and we have said it in the submission, we have, and our position is we have more than fully complied with the requirements of UNCLOS on the things we have to do before filing the claim. Now, to the second question, and it was, yes, indeed, debated much by the policymakers who made the decisions before we came forward. We went forward with the suit. What if the Philippines gets a favorable award, and what if China refuses to accept it? And again, obviously, there's nobody to enforce it. And again, the Philippines, as a small country, a part of the community of nations, is hoping that whatever persuasion a well thought, reasoned arbitral award will affect China. But again,
What about your neighbors? You see, one possibility would be they all share your concern about the 9-dash line. They could all try to intervene, bring their own suit. I don't know technically what the possibilities are. Your other specific questions are Philippine-specific issues, but they have their own islands, rocks, features to worry about. And if I were Vietnam, I would be thinking very seriously about somehow associating with this effort through intervention in the case, through bringing their own case, or at least making some public statement of support. I'm listening for Indonesia, Malaysia. I don't really care what Brunei does, but I probably should. I think Professor Koo is right. We don't see, at least in the American media, evident support for what you're doing. If I were Japan, I would be showing support for this, and I hope the Japanese will become more public in moving China toward a international dispute resolution at the ICJ on their own problems, or before the Law of the Sea Tribunal. I think this is the time for all the countries that do not want to engage in force to support international law, even though their diplomats poo-poo international law. I get very annoyed at our own American diplomats. They don't take this. We had a conference at the Asia Society not so long ago, and they don't take this very seriously. You had people at the Asia Society for this purpose, and the American diplomats I was very annoyed with. They just think nothing useful will come of this, and I think they're missing the boat, but it wouldn't be the first time.
Yes, we're very hopeful, but we have talked to our friends, talked to our neighbors. We're still hopeful. You've named some of the countries. Some should have more reason to have been, in fact, ahead of us or with us. But we're still working on it, and it's one of the ironies. I think in the last 2 days, the European Parliament has gone out with support, and we get support from outside the region. But we're working very hard in ASEAN to get multilateral support, and again, we're open to talking with China.
Yes, Peter, do you have a point?
Well, a question actually, but why don't we give Professor Lee first? He hasn't asked yet.
Oh, good. And we also have one of our key students here.
So this is also a question out of curiosity. It's a question about timing. Why
Can
now?
you speak up a little louder? Use the mic closer, thanks.
A question, just out of my curiosity, about the timing. Why now? Why, you have been in negotiation with the Chinese government for 17 years, as you said. Why this year did you file a submission for arbitration over this dispute? And why this year? Why not wait another 10, 15 years? I mean, what happens? What caused this filing in the first place?
Ira?
If I could just add to that, why in December? In between.
Why what?
Why was it filed? It was filed in December, right?
January 22nd.
Between the 18th Party Congress and the National People's Congress meeting during a leadership transition in China.
Well, that's looking at it from the internal Chinese point of view. You could look at it from other points of view. For example, Philippine nationalism. How long are they going to get pushed around in this humiliating business of having Chinese boats invade what they regard as their economic zone? The government is under pressure from the people. We worry about nationalism in East Asia, but I'd rather see nationalism in favor of going to litigation than nationalism in favor of gunboat diplomacy, which is what we've got in Japan and China now. So there were political reasons domestically to do this, and how long should they undergo this harassment, after all? So, and it's put China back. China was pushing everything, and this has set China back. And the whole international relations in the South China area, South China Sea area, I think have been upset because what they've done is not a conventional international relations move. So I'm all for it. You're breaking the stalemate.
Well, the answer to the
Yeah,
question
please.
is, I said towards late last year and culminating in some time in November. I said this was when the Chinese went into Scarborough Shoal, pushed out all of our vessels, And again, the question is, what's next? We have been fishing in that area, and the Chinese had never done it before in terms of pushing back. They're in the shoal. They had 3 vessels. There were efforts, there were diplomatic efforts. It was brokered to pull out, and our position is China did not pull out. And so, in that light, we were at the end of the options. For example, our exploration activities down in the Spratlys or the Reed Bank, China has made pronouncements about not honoring contracts made by the government. And the other thing I forgot is, and I want to stress, I think last year China had a new law setting up a new structure under the province of Hainan.
Mm-hmm.
And that law was going to be effective January 1, 2013. Basically, it says that the Chinese vessels can stop, accost, inspect, or detain vessels of other countries within, basically the 9-dash line. So, if towards September, November, we were being shut out of fishing rights, and then you have the new law, and everybody was just getting scared. January 1 of this year, what will we do if we are accosted? We cannot get rights because we are not in UNCLOS. We cannot get provisional remedies. So things happen also very fast from our end. And
Yes, you were trying to reduce the likelihood of further clashes.
Yes.
And the economic costs are very great. They have to postpone economic development in the area, and the uncertainty and foreign businesses that are related to economic development. They don't want to come into a place that's unsettled legally, and that's hindered Vietnam's development off the Paracels and other areas. So I think the sooner you can get a legal resolution, the better. I think it's a very important point. Eli?
I don't want to jump the queue. I think Professor Dutton had no. Okay.
Well, he's being very patient. And now
So-
the discussion is heating up when we're overtime. I'm delighted.
First of all, thank you so much for coming, following this issue for this year. And it's very, very exciting to see what's happening I want to build a little bit on what Professor Koo was asking. I know that people are sort of interested in how other ASEAN countries are relating to the 9-dash line. But I think another issue is that from the outside, it seems like there's a perception there's not quite as much reliance or just communication between other countries themselves with each other. And I'm wondering if this is accurate. You know, have all the other borders between countries in the South China Sea been settled? If not, do you think there's any chance of this kind of move instigating more moves, if not to challenge China, to just demonstrate commitment to UNCLOS, and how that might relate to what you're doing in the region?
Well, as I said, I assure you, we have been talking with our neighbors. You know, each, as Professor Cohen has said, will have peculiar diplomatic reasons or other reasons to come forward sooner rather than later. But we have been talking, and then, you know, at a certain point, you know, as I explained, our own interests, Scarborough Shoal, the Chinese municipal law, you know, the Philippines had to decide on its own, and we generally, I can say, we have been talking, but you know, at a certain point, we had to decide on our own. And again, it doesn't bar them from joining us. We certainly are hopeful that one or two or more could join us, because from the point of view of our interest, we see basically the same interest. If we can delineate what is disputed and what is not disputed, we see no reason why ASEAN cannot, you know, multilaterally sit down with China. But again, the starting point is UNCLOS-based rules. Where do you count our 200? From where do you count our 200? From, you know, is this an island? Is this feature a rock? And until those issues are settled, all of us will be at a disadvantage if China just claims, you know, based on this big coverage of the 9-dash line.
We want to hear from Mr. Nagase, who is the Deputy Consul General of Japan here in New York.
Yeah, thank you very much for the great presentation. You talked about, Professor Cohen mentioned other Asians' point. So let me briefly comment Japan's position on South China Sea. We commend Philippines' approach to bring this issue to arbitration in order to solve this problem based on international law, especially UNCLOS. We believe rule of law is very important. Then this South China Sea issue should be solved based on international law, not by unilateral action. So we really recommend that.
Thank you.
And
thank you.
as for East China Sea and ICJ, I want to point out Japan has accepted jurisdiction of ICJ. So maybe you but unfortunately, China has not accepted jurisdiction of ICJ. So please ask Chinese colleague about this option.
This is a very good point. In October, I wrote something in the South China Morning Post and in the Taiwan newspaper calling for the countries to consider arbitration, adjudication, international law, instead of, I think they're heading for a train wreck in both places. In November, before his party fell from power, the former Japanese foreign minister, Mr. Gemba, wrote an International Herald Tribune op-ed where he said, "We Japanese are for international law. We have accepted the ICJ compulsory jurisdiction, unlike the US, unlike China. If China is so confident of its position on the Senkaku, let them take us to the International Court of Justice." When I read that, I was really excited. My eyes were popping. This was the first break in this logjam in the East China Sea and the South China Sea. I thought, great. But then Mr. Gemba had to leave office. Nobody seemed to pay any attention to what he wrote. I didn't see anything in Japan. Nothing here. I was the only one who seemed to notice. And I thought, this is really dead. And some of our experts on Japan said, it shows this guy was it was full of hot air. He's not representing anybody with that proposal. But we've subsequently learned that this is still the policy of the Japanese government. This wasn't one man's flyer. It comes right out of their bureaucracy. And then you come with the two-punch on the 1-2 punch for international law, January 22nd, going further than Japan. And I hope the Japanese government will make its position public, endorsing what's been happening. Excuse me. Yes, please. As I understand it, you represent the office of the President of the Philippines. Is that right?
Yes, Professor. And I was just, thank you.
You're an LLM graduate of Columbia Law School?
Yes, class of 98.
See that? What is your name, please?
Anne-Marie Corominas.
Well, we're glad you're here. We try to civilize people from Columbia all the time.
Well, pleasure to be here, Professor. I just wanted to add to the answer of why now and why not, 10 years from now and why not before. And I think that it actually has a lot to do with the current president, our president, President Benigno Aquino, because he entered into office in July of 2010 when the Solicitor General also entered public service. So I think he has the foresight and the belief in the rule of law and in a rules-based approach. So he was willing, I think he's a man of strong conviction, and he was willing to take the risk of believing in international law.
I had the pleasure, as I mentioned to Mr. Jardeleza before we came here, of introducing President Aquino's father to Harvard University, where he spent a very happy year learning more about our views of international affairs, etc. And on that occasion, the Aquinos invited me for dinner. And I always say, Mrs. Aquino is the only president who ever cooked me supper. And she was a good cook. And the president was just a kid who was there. And little did we think it all would come to this. So we're very happy to see you, and we hope you'll tell President Aquino that some of us are very enthusiastic about what you're up to.
Thank you so much.
Can we have a final, okay, because, yes, please, Heidi, you always wait to the end. I didn't see it, go ahead.
Well, my question is, as a lawyer myself, before you bring in a legal action, you always anticipate what would be all the different kind of outcomes. Suppose here, if China continues to ignore, even if after you have, let's assume you'll get a favorable whatever decision from the court, and China would just completely ignore it. And so you must have anticipated this, I assume. And then what's the point of this? Are you just trying to achieve some moral victory? It's kind of like an international shaming scheme towards China. So what are you going to achieve from if that is the scenario?
Well, the answer is, what do we want to achieve? We are all lawyers. We want to achieve a legal victory, a legal victory under international law.
But what if it cannot be enforced, assuming you are going to?
And then that's really for China to ponder and consider. And as far as a member of the community of nations, we believe in a rules-based international legal order. And if everybody takes the attitude that what if the other countries will not do that, then there will be no place for rules-based international law. And so we did consider that, and it shows the abiding faith of the Philippines as a member of the legal community. Again, we go back to law. We are not here to achieve a moral victory. It's a legal victory, and we are hoping that the tribunal would come up with a well-founded, well-structured well-reasoned award. And if the award doesn't go our way, we will take it. But if the award goes the other way, we hope that China, as a member of the community of nations, will give respect for the rule of law. And again, because this has been asked, are you here for a moral victory? No, we are here for a legal victory.
But the question is an important one and reminds me of our need to consider two things. One is different countries, because of their political legal culture, may have different reactions to the same legal gesture or action. The other is nations change over time. They learn. They acculturate international norms. And why do I say that? First of all, I think it's important to know in the 70s, the late 70s, I started taking interest in arbitration, settling commercial disputes with China. At that time, 1973, at the Guangzhou Trade Fair, Chinese officials said to me, arbitration is a very unfriendly act. I'd say, all your business contracts call for arbitration. They said, it's very unfriendly to try to use that. Well, that's not China's attitude today. China has invested heavily in international arbitration, domestically, internationally, and they know bringing an arbitration is simply a way of settling some legal claims. I was involved in 1980 or so in one of the early disputes between China and an American company. And the American company felt there was a clear violation of the contract, and they said, tell them, I had to do the negotiating, that we're going to sue them in New York County Court. And the Chinese reaction was, we're willing to talk settlement, but not if you're going to bring a case. Once you bring a case, that shatters our friendly relations. And I said, in our culture, bringing a case often leads to a resolution of the dispute. So I saw the difference in attitude, but of course, Chinese have changed their attitude very much on that, and indeed, in that case, we finally got a settlement. It was the threat of a lawsuit that brought them around to it, but the initial reaction was very different from one we might have got here. So there are cultural questions here. And I think China and the WTO, that's why I cited it earlier, it shows their ability to adjust to an international system, because in the long run, that's in their interest. And I think that's what's at stake here. And that's why I hope China will think twice or three times. There must have been very heavy discussions in Beijing about this. I'm sure people in the Ministry of Foreign Affairs, which has a very good law and treaty division, I'm sure they argued for going at least the first step in this arbitration process. But unfortunately, the ministry and the legal people are not very strong in the Chinese government. But my hope is their position will gradually improve. This has been a terrific discussion. We're very grateful to you. You have stirred up the masses, as we say in China, and we hope to follow the progress of this and remain in close contact with you. Thank you very much.
Thank you. Thank you to everyone.